Distinguished members of the court, it is an honor to appear once again before you and to do so on behalf of the Republic of Turkey. Article 7 of the Convention, first and foremost, serves as a safeguard against arbitrariness. There was nothing arbitrary in the applicant's conviction. In Yalçın Kaya, the court decided that the offense of membership of an armed terrorist organization was clearly defined in Turkish law. That is, an individual could know from the wording of the relevant provisions, complemented by the case law of the Court of Cassation, what acts would make him criminally liable. The material and mental elements of the offense were clearly defined at the time of the applicant's acts between 2011 and 2014 and have been set out for the court's convenience in the synopsis submitted by the government as document number 1. Let me summarize these elements. On the material side, the defendant must have had an organic relationship with the organization. That is, he must have become part of the hierarchical structure of the organization and made himself available for orders and instructions of the organization. He must have made a material or mental contribution to the organization's actual existence or reinforcement. There is no requirement that a defendant himself used force or committed crimes. On the mental side, the defendant must have acted knowingly and willfully. This means he must have had knowledge of the illegal objectives of the organization and that the organization used or intended to use force to achieve these objectives. The defendant must also have had the will to join the organization on a continuous basis, act within the hierarchical structure of the organization, and contribute to achieving the objectives of the organization. Contrary to the applicant's assertion, there is no specific intent requirement. As the Court of Cassation noted, intent refers to the materialization of the elements in the legal description of the offense willfully and knowingly. Absent a confession, both the material and mental elements of an offense are generally inferred from a defendant's conduct, established by evidence. According to the Court of Cassation's case law, the organic relationship with the armed terrorist organization and that the defendant acted knowingly and willfully within the hierarchical structure of the organization can be inferred from the continuity, diversity, and intensity of the acts attributed to the defendant. The Court of Cassation's approach to establish the material and mental elements of the offense of membership of an armed terrorist organization has been acknowledged by this court in the cases of Demirtas versus Turkey, number 2, Yüksek versus Turkey, and Demira versus Turkey. This approach is not very different from the court's own approach to proof. As spelled out in Ukraine and the Netherlands versus Russia, I quote, "Proof may follow from the coexistence of sufficiently strong, clear, and concordant inferences or of similar unrebutted presumptions of fact." Establishing the material and mental elements of the offense by inferences from the continuity, diversity, and intensity of the acts attributed to the defendant is not arbitrary, and in the light of the established case law of the Court of Cassation, was clearly foreseeable. FETÖ, PDY, was of course not the first armed terrorist organization before the Turkish courts. In March 2016, the Venice Commission adopted a report that dealt inter alia with Article 314, paragraph 2 of the Turkish Criminal Code and the question of membership of an armed organization. The government has submitted the relevant parts of the report as document number 20. In paragraph 100 of the report, the Venice Commission noted, I quote, "There is a rich case law of the Court of Cassation in which the High Court developed the criterion of membership in an armed organization. The Court of Cassation examined different acts of the suspect concerned, taking account of their continuity, diversity, and intensity, in order to see whether those acts prove that the suspect has any organic relationship with the organization, or whether his or her acts may be considered as committed knowingly and willfully within the hierarchical structure of the organization." End of quote. Of the 10 cases the Venice Commission referred to in order to illustrate the rich case law of the Court of Cassation, 9 were decided before November 2013, the large majority between 2007 and 2012. Their continuity, diversity, and intensity included acquiring a code name, giving courses on the aims and structure of the organization, and driving newcomers willing to become members of the organization to the camping place of the organization. All acts that as such are not unlawful. The applicant is thus barking up the wrong tree when he claims that he was convicted for lawful activities. A distinction must be made between the criminal offense, here membership of an armed terrorist organization, and the lawful or unlawful acts attributable to a person that may be used to prove the elements of the criminal offense. In order to illustrate the established case law of the Court of Cassation, the government has submitted as documents number 21 to 25 several decisions rendered prior to 2014, where the Court of Cassation upheld the inference of the material and mental elements of the offense of membership of an armed terrorist organization from the continuity, diversity, and intensity of the acts attributed to the defendants. Of particular relevance to the present case are the decisions in documents number 24 and 25, where the Court of Cassation based the conviction inter alia on the use of code names. Taking into consideration the position of the accused within the organization was also nothing novel in order to establish the elements of the offense. As seen by the decision submitted as document number 26, the Court of Cassation upheld a decision of May 2013 in which persons were convicted for membership of a terrorist organization on the basis, I quote, "their roles within a student association which was operating under legal disguise within the scope of actions of the youth wing of the PKK terrorist organization. The Venice Commission did not call into question or criticize the Court of Cassation's approach to use the established criteria of continuity, diversity, and intensity of acts attributable to a defendant in order to show his organic relationship with the organization and prove that he acted knowingly and willfully. It only recommended that the criteria be applied strictly. It is the government's submission that in the applicant's case, the criteria were applied strictly. In contrast to the court's finding in Yalçın-Kaya, the domestic courts did not just use one act on its own as conclusive proof of the material and mental elements of the offense. The difference between the two cases is clearly illustrated by the table comparing the acts attributed to the accused. The table is document number 3. As can be seen from another table, submitted as document number 2, in the present case, 8 different acts could be attributed to the applicant on the basis of a wide range of evidence. These acts stretched over more than 4 years, and over these 4 years, the applicant's relationship with the organization became ever more intense. From just living in one of the houses of the organization to managing more than 20 of these houses, adopting a code name, and finally becoming responsible for several thousand students living in the state dormitories in Çorum province, while at the same time working for a company affiliated with the organization. In his observations, the applicant focuses on individual acts in isolation in an attempt to show that each, on its own, cannot establish the constituent elements of the offense. Such an approach, however, is divorced from reality and judicial practice. In its decision, which has been submitted as document number 6, the Çorum Assize Court emphasized that it was necessary to consider all the activities individually, and I quote, and as a whole. And it is submitted in the context of the general knowledge about the terrorist organization in question. The applicant focuses in particular on 2 individual acts, the position as BBTM and the use of a code name, in order to create the misleading impression that he was convicted solely on the basis of these 2 acts on their own, and that there was some kind of automaticity between these acts and his conviction. Nothing could be further from the truth. The domestic court established the constituent elements of the offense in an individualized manner. There was no automatic presumption of guilt based on the position of BBTM or the use of a code name. The applicant could have exonerated himself from the allegations, but he chose not to do so. On the contrary, he denied any relationship with the terrorist organization despite clear and overwhelming evidence to the contrary. The applicant's conviction was by no means based solely on his position as BBTM. The Assize Court took account of the fact that over the years, the applicant held 4 different positions, regularly being promoted and rising through the ranks until he finally reached the position of Ilchi in 2013 and 2014. That is, the person responsible for several thousand students living in state dormitories. The applicant tries to downplay his position and activities within the student organization of FETÖ PDY, concealing that student recruitment and fostering played an important role in the overall strategy of the organization to overthrow the constitutional order. Contrary to the applicant's allegations, there was nothing automatic between his position and the conviction for membership of an armed terrorist organization. In the decisions submitted as documents number 28 and 29, the accused was acquitted, despite being a BTM like the applicant. But unlike the applicant, the accused did not use a code name, did not engage in organizational activity after the December 2013 events, did not have a bank account with Bank Asia, and did not have any employment with the FETÖ PDY affiliated entity. It is thus not the single act of holding a certain position, but the continuity, diversity, and intensity of the acts that helped to establish the constituent elements of the offense. The applicant also tries to call into question the use of code names as proof to establish the constituent elements of the offense, alleging, without providing any evidence, that the use of code names was a tradition practiced by several religious groups in Turkey. This is refuted by the letter of the High Board of Religious Affairs submitted as document number 19, and the fact that the use of code names served as a basis for conviction for the offense of membership of an armed terrorist organization, as seen by the decisions submitted as documents number 24 and 25. The Assize Court convicted the applicant not on the basis of the two acts, but on the basis of the, I quote, entire case file as a whole. As set out in the table in document number 2, the case file includes 8 different acts, including the applicant depositing, upon instructions, money with Bank Asia. Unlike in the Alçınkaya case, the Çorum Assize Court used the applicant's exceptional deposits in his Bank Asia account as substantial evidence, not in the sense that it could prove membership on its own, but as one of several acts proving organizational activity. This finding was reached not just on the basis of the deposits as such, but also on the basis of the applicant falsely claiming that the money in question was transferred to his account as his salary, while the bank records clearly showed that the deposits were made with the applicant's bank card via a cash machine after the leader of the organization had instructed members to make deposits. The applicant claims that in the present case, the mental elements of the offense were not established because in 2014, no one could have been aware of the terrorist nature of FETÖ PDY, and therefore its characterization as an armed terrorist organization was not foreseeable. The question, however, is not about general foreseeability, but whether the characterization was foreseeable for a person with the applicant's position within the organization. The applicant is simply wrong when he claims that for the presence of the mental elements, he would have had to know that a coup was coming, or that legally there can be no armed terrorist organization before the first violent act. There is no support for such claims in Turkish law or in the court's own case law. On the contrary, as the court held in Yalçınkaya, the fact that FETÖ PDY had not yet been classified as an armed terrorist organization when the applicant carried out the various acts does not preclude the criminal liability of members of the organization for acts undertaken before such classification, to the extent that they acted knowingly and willfully. In line with the established case law of the Court of Cassation, the Çorum Assize Court established on the basis of the diversity, continuity, and intensity of the acts attributed to the applicant that he was acting knowingly and willfully within the hierarchical structure of the organization. Members of FETÖ PDY in the applicant's position would have known about the nature of the organization long before this nature became known to the general public. In any case, the organization's terrorist nature became generally known after the events of December 2013. As the Constitutional Court noted in the Adnan Sen case, many investigations regarding the organization and its activities were carried out especially after 2013. This was implicitly confirmed by the applicant in his submissions to the Chamber in the present case, where he claimed that he had left work with the FETÖ PDY affiliated company following the December 2013 investigations upon, I quote, the request of his family. For establishing the mental elements of the offense, it is of relevance that the applicant did not leave the organization after its terrorist nature had become known to the general public, but continued to perform his organizational activities as ilçi and continued to work for a FETÖ PDY affiliated company. The Çorum Assize Court also put particular emphasis on the fact that the applicant made the deposits in Bank Asia upon the instructions of the FETÖ PDY leader after December 2013. In addition, the fact that the applicant claimed that he had nothing to do with the organization in the face of the overwhelming evidence to the contrary will also have been taken when establishing the mental elements of the offense.
Mr. Talmon, I have to inform you that the government side has spoken more than 30 minutes already, so I would kindly ask you to wrap up.
Thank you, Mr. President. Let me, so to speak, conclude. In light of the entire case file as a whole, the applicant's conviction by the Çorum Assize Court on the ground that I quote, the applicant's acts and activities which involved diversity, continuity, and intensity attained the level of membership of a terrorist organization was in no way arbitrary, and in light of the established case law of the Court of Cassation, was clearly foreseeable. There is thus no violation of Article 7 of the Convention, and the application should therefore be rejected. I thank the Court for your kind attention.
Thank you very much. I thank the government side for their pleadings.